Welcome, and thank you for standing by. Today's conference will be on a listen-only mode. During the question-and-answer session, please press star 1 on your touch-tone telephone. Today's conference is being recorded. If you have any objections, you may disconnect at this time. Now I'd like to turn your call over to Janice Wingo, International Trade Administration. Ma'am, you may begin.
Thank you, and good morning. Today we're very lucky because we have lawyer He Jing from the Beijing firm of ZY Partners to talk about his punch list on IP enforcement. Just to give you some background on lawyer He has a degree in physics from Peking University. Then he obtained his Juris Doctorate degree from the University of Notre Dame. He's admitted to the bar in California, and he worked for a large U.S. law firm in California and then another one in Hong Kong. So he has over 10 years of practice experience, and now he's with ZY Partners, where he assists people in China. Lawyer He said he'd be willing to take questions after the recording, so please hang on the line so that you can ask him some questions. He Jing?
Hi, thank you, Janice, and thank you, everybody who joined this webinar. So today I will just highlight some of the key actions we think that may be quite useful for the companies that were interested to conduct business in China. Now, I summarize them as 8 actions. In fact, of course, there could be more actions to be done, but we think this, giving you a list may have you to concentrate on some of things that could be very important in China. And for those of you on the audio, but you are not able to see the slides right now, I just want you to quickly list out some of the key actions I'm going to talk about today. So these are 8 actions, and I think that register your IP is found as probably the most important one. And then I will talk about the rate actions, what are the kind of rate actions you could take in China to stop the infringement, and to clean up the internet sites. And number 4, I list out the scaled trade fair for infringement. You know, China has some very big trade fairs where many people find that their products, the innovations were copied and then displayed at those trade fair for the potential customers. And the number 5 actions I propose here is a stop shipment at the borders. Many people are actually may not be really fully aware of that China has a very effective customs seizure actions in place that could be helpful for the IPR owners. And the sixth action is the freedom to operate. So people are really targeting at the China market that the risk of patent infringement is actually becoming a substantial kind of a risk, and people really need to consider. The 7th action I'm going to talk about is about the civil actions, and a lot of companies have still valid, justified fear about doing the civil actions in China. But I want to say a little bit about the civil actions in China. So you may be starting to think about whether civil actions could be something you could do in the future. The last one I will talk about the acting in groups. Now, the first action, I want to talk about the registration IP in China. For those of you who may not be really, done a lot of studying or research in this area, just so you know, in China, you can register your trademarks, you can register and file your patents, and you can file design patents to protect your design. And, copyright is also protectable in China. You don't really need to register it. Of course, if you have a registration, that would be helpful. But, the copyright, once you have a copyrighted works in place, then the copyright is recognized in China. And also plant variety rights is also protectable in China. And so for those of you in the agriculture area, that's some inventive, the plant variety may be, be protected in China. So why the registration of the IP is important? Just taking the trademarks as an example, some of you may have heard that the problem of trademark squatting, right? What we typically talk about the cyber squatting, which is more about the domain name. But unfortunately, in China, because the country is so big and the system is relatively less developed, so there are many Chinese factories, individuals. They take advantage of the the timing difference of the foreign brand owner into China, they actually managing a way that they register the foreign brand owners on trademarks in China, using that for commercial advantage. Sometimes they want to sell the trademark at a very high price. Sometimes they just actually launch their own product, own their service under those names. So in this slide I'm presenting, I just list some of the examples of the squatted trademarks. And the next slide actually shows some latest examples. One of is the Chivas Regal. We all know the Chivas Regal is a famous, popular liquor brand. A Chinese individual just filed this mark for clothing. About 9 years ago, the Chivas Regal filed a case trying to stop the registration of the trademark. But unfortunately, after almost 9 or 10 years fight, the Chinese local court still not rule in favor of the Chivas Regal. This company has to keep fighting in the court. Probably the case may end up being the Supreme Court. Another example is Little Viagra. Okay, and another individual, almost exactly the same time, back in 2003, applied for the Little Viagra mark in printers, electronic dictionaries. Again, in this case, Pfizer applied to oppose this mark, but it has not been really successful. The latest court decision in Beijing, again, does not really support the decision of Viagra. The reasoning is, hey, the Viagra wasn't that well known back in 2003, so the court is not willing to support the Pfizer in this fight. So cases like this actually it's not really uncommon. We have heard many instances like this, like the foreign companies are really find this squatted trademarks, the bad faith trademark applications is one of the big headaches in the trademark area. So again, why it's important to do the registration? For people who on this call, but you are not the lawyer or you're not really doing the IP law. Just so you know, the IP is really territorial, which means that when you have a trademark in the U.S., in Japan, in Europe, it does not mean that you have the protection in China. If you have a patent in the U.S. or in Europe, but you have not registered that particular piece of a patent in China, then your patent actually is really not protectable in China. You may still protect it in the U.S., but you have very little remedies to protect your patent in China if you have not registered it. Okay. And another more probably important factor is China actually, even though the IP system is relatively young, probably only for the last 20, 30 years, but the Chinese business people, the awareness of IP has really increased in the last 10 years. The people just know IP is important now. People register lots of brands and lots of trademarks and lots of patents. China is probably one of the has recorded one of the highest filing of the patents in some of the areas, and the growth rate is still about 30-40% in the last 5 years every year. So the message is, if you have not refiled your trademarks or patents, register them in China, the chances are your competitors, Chinese or non-Chinese, they might do that. Okay, if they register the patents which you don't, and they also cover your product, that could really become a problem for you. And say it another way, and if you have registered your patents, even if you are a small company, when you have some good protection in China for your patents or trademarks, especially for patents, actually, it may really give you a very unique tool to deal with those big-size competitors, whether the big Chinese companies or the Western companies. I'm not saying here, the patents can deal with every issue will really help you win, the market, capture the market. Okay, but when you have the patents, that will really give you yourself a huge favor, huge advantages. Now, here I also want to offer some quick tips on developing the IP portfolio. Okay, just repeat what I said earlier. Finding the time is very important. File as early as possible. The second tip is protecting your marks in Chinese characters. If you are really serious, if you are interested in the China market, okay, and we highly recommend our client to come up with Chinese marks. Okay, sometimes it can be just a transliteration. Sometimes it can be a completely new, the new way of saying your mark, Chinese characters, or just pick the popular Chinese name that people recognize your mark or your service and register that for yourself. If you don't do that, again, someone else might have done that, and then that will block your chance to pick a very good Chinese name. The number 4 tip is being careful about what you done in the patent prosecution stage. Okay, for those of you who are on this phone call, if you're interested in doing the patent filing in China, it's just remember this. Actually, what you do in the filing stage can have a very big impact on the value of the patent in the future. Okay, the quality of the drafting, the quality of the translation is the key to make sure your patents are useful in China. The last the tip, again, related to patents. If you have the same patent filed in the U.S. and in Europe, be mindful what you said or what you done to the U.S. patent, the European patents in those countries. What you said, what you have done with the U.S. Patent Office or European Patent Office may be used against you in China in the future. Okay, it's not really intentional, or it's not because Chinese Patent Office want to do something intentionally bad against a Western company. It just becomes some doctrine in the patent practice that whatever you say outside China could be considered by the examiners in China. Again, this is about the quality of the patent drafting and patent examination. So these are just some of the tips we would like to offer for you in developing the IP portfolio in China. Now, the next one, action I want to talk about here is about doing the raids. This is more about the enforcement. Okay, if someone infringes your IP rights, what are you going to do? All right. Basically, I just want you to be aware of that. There's 3 major ways for enforcing the China IP. The first one is what we call criminal actions. Right. This is one really done by the police actions, and the second one is civil actions. We call the IP owners. File the lawsuit in the court. The third one is administrative. This one it's very unique to China. China is sometimes really proud of it. They always keep saying, hey, we have an administrative route to enforce an IP. This just means that instead of going to the court, going to the police, you're going to the administrative authorities of the government to say, hey, I need you to do the raid actions. The advantage of administrative actions is that it's relatively cost efficient. Okay. But the problem is that it's not really deterrent enough. If you want to say, hey, I want to do something, I want to put that person in jail, this is not an option you want to go for. All right. Normally what happens is that the administrative authorities will impose a fine. They will seize the counterfeits, the pirated items, and destroy them, and that's about it. Okay. And some IP owners are frustrated because, hey, the same infringer may come back after some time. But some people like it because it's relatively quick and dirty, and they can deal with some visibility problems. But it's definitely not one that you want to rely on if you are dealing with some large-scale infringements in China. The number 3 action I want to talk about here is to clean out the internet sites. It's really exaggerating to say here using the term clean up internet sites. For those of you who are not, familiar with the situation in China about the internet shopping or the e-commerce in China, I just want to say that the internet shopping, the online trading, are really thriving in China. Okay, and many people, especially in the urban cities, and the younger generation, or actually even in the middle-aged families, they're really using the internet shopping a lot to buy almost everything from groceries to clothes to electronic devices. It's a huge market, and people just love buying things from the internet like everybody else outside China. Now, that actually creates a problem for the brand owners, for the IP owners. And because it's much harder to trace infringers from on the internet, and the consumers are much easier to be misled, by looking at the pictures on the internet. So right now, the IP owners has been trying to put a lot of pressure on those large trading platforms. Like in China, we have Taobao, we have Damdang, and we have quite a few very large the online trading platforms. But so far, the online trading platforms have been responding to some of the pressures. But given the size of the infringement, given the scale of the problems, nobody has really come up with an effective solution. And the online trading platform, understandably, does not really want to take up too much work to do disciplinary actions, to clean up everything, to monitor actively on what's on their website, right? And the government is also really scratching their heads of what exactly can be done. So this is one of the areas. If you are caring about, if you're really interested in China, the market, want to do business, want to have your brands of the good designs, available in China for the China consumers, you really need to check out what's going on in those the Chinese internet sites. And some of this, the findings may be really surprising to you. The fourth action is related to the trade fairs. This could be important for, especially important for the people who are doing lots of OEM business in China. Okay, you have your own innovative design, you put that in China, you want to take them out, you make the ordering and then you ship them outside China. And infringers often display the infringing items at these trade fairs. Okay, they copy the designs, they offer the same thing probably at a much lower price. So it's if you are in the OEM business or you are caring about the China market, I highly advise you to think about doing some IPR cleanup actions at the trade fairs. The trade fair organizers work with the local governments, have some mechanism to do the very quick rate, at least ask the infringer to withdraw or taking the stuff off the shelf, off the display counters. Okay, it does not mean it doesn't mean it's a decision of infringement, and the trade fair organizer will not impose a fine. Okay, eventually, if you want to continue to deal with that, you have to go through enforcement approaches like the civil action or criminal actions. But the cleaning up of the trade fair have the controls. It's relatively important for you. The number 5 action is stop counterfeits at borders. In China, it's very unique. The customs inspect both imported goods and exported goods for IP infringement. Not many countries are doing the inspection on exported goods for IP infringement. Okay, and the Chinese customs. It's fair to say the Chinese customs is probably one of the most competent and proactive, the more organized enforcement agencies in China. Even though there's still a lot of big brands are not really satisfied with what they've done every time when they see the huge containers of counterfeits arrive at the port of the U.S. ports. But still, if you look at the seizures or customs actions at the Chinese ports, it shows that the Chinese customs, at least doing the checkings when the suspicious items are discovered, they really see that. They may send a notice to the brand owners, say, hey, whether this is counterfeit, do you want to take action or not? So, but to really make that work, you have to have your trademarks in place, registered in China, and also record. It goes through some recordation procedure with the Chinese customs authorities, which is not really hard. It's not expensive at all. And have a system in place, and ideally do some training with the local customs officials so they are familiar with the brands and have the action done. But just so you know, if you're really going forward with the customs procedure actions, you have to get the paperwork done, and also you need to be prepared to deposit some monetary bond. In case the bond requirement is prepared by, it's really required by the customs, just in case something goes wrong. In case some parties abuse the procedure. So, but the amount of bond is not very high. Okay, it's part of the scale. The scale links to the amount of the goods or amount of the declared value of the seized items. Now, before I go to the next station, here I just want to offer you a very quick summary about the anti-counterfeiting strategy that we often recommend to our clients. In China, because the scale of the problem is quite big, and also because the resources, the enforcement resources is relatively limited, and it's also fair to say that so far the IT enforcement is really not on the very high priority of the government. So it really takes stamina and really takes persistence to deal with counterfeiting and piracy. Okay. Normally, the smaller companies are finding it very challenging to have the problem resolved in China, and the bigger Western companies, because they have a much bigger presence, they have much stronger local teams, they probably get more attention from the Chinese government. So for smaller companies, don't really hope that it can, the problem can go away overnight. And to some of the business, the reality is it's really part of the competition in the market. So this part you have to be really realistic. But you cannot give it up. You probably cannot afford to give it up at all. If you don't do anything, and the counterfeiters, they will smell it. They know which brand is the most vulnerable. If you go to some of the very notorious Chinese retail wholesale markets, you can see some of the well-known brands are much less visible than the other brands. Why? Because those most visible, the counterfeited brands, are probably the brands that are totally cynical and hesitant about doing anything in China. So their brands end up probably the biggest victims in those markets. But for the other brands, they because of the stake market, they spend a lot more resources. The actions have produce some results. And whenever you got a good case, whenever you find a good case, the evidence is clear and in a good location where the enforcement authorities are more reliable, we highly recommend you select and win the cases you can win. The number 6, the clear risks of infringement. This is what we talked at the very beginning. We call it the freedom to operate. For the companies that are really willing to launch a product in China, or even doing a lot of manufacturing and export out of China, the patent infringement is something we really need to think more about it. As I said at the very beginning, the Chinese companies are finding more and more of the patents in China these days, and some of the patents are good quality. Not everything is bad. Of course, there are a lot of we say junk patents, but some of the patents can cause a big problem to you. The example I put on the slides is the Schneider case. Some of you may already have heard about it. It's probably the most famous China patent case so far. Right? The French company lost the patent case to a local competitor in the Chinese court. The Chinese court ordered about $40 million US dollar as damages against the other side, against the Schneider. Of course, people have very different views about whether this case is fair or not. But I think it's fair to say this case is one of the examples to demonstrate it's quite important now for U.S. companies or European companies that are doing business in China to really doing some serious patent research and figure out whether the key products are of any risk of infringe someone else's patents, maybe your key competitors, maybe Chinese competitor or non-Chinese competitor. Just doing a check, it does not really necessarily cost that much, but it's good to have this practice in China as well. We have seen the local companies are getting really savvier with the patent strategies. They know how to use the patent lawsuit to disrupt the competitors, the business strategy in China. The number 7 action, I want to talk about civil action. Okay, it's for smaller companies filing a civil action and doing a court case in China probably sounds like a daunting task. If you have never filed any cases in China. Okay, we're not really trying to convince anybody here to just, hey, just go to court to file the case, right? But the point I want to make here is that it's getting closer to the time that you should really look at this as an option when you get into disputes. Actually, it's not just IP dispute. It could be the commercial type of disputes. The court action may be something you should really consider about, even though there are so many imperfections these days. If you just suspicious about it or just worried about it, it just really limits the way you can take effective actions. In China, the reality is that the IP disputes are really fast growing. About every year, about in the past 5-6 years, every year is about 10 or 20 or even 30% growth rate. Last year, in 2011, the total number of IP cases is already reaches 50,000 cases. 50,000 cases. In comparison, I believe in the U.S., the total number of IP cases are about something around 9,000 cases. Of course, when I talk about the numbers, we are running risk of comparing Apple with orange. Okay, the stakes are quite different. There are a lot of very smaller type of claims in IP cases in China. But I just want you to know that Chinese litigants are Chinese parties getting more and more litigious. Okay, going to the court is not something they're ashamed of, and the Chinese judges have seen quite a few, a lot of foreign companies come to the Chinese court to litigate. So they are getting more and more experience, and just taking an example of the patent cases, Chinese court cases are moved quite relatively fast. Most of the cases can be really concluded in 2 years. For the court first instance, you can pretty much get that done in 1 year. Okay, that's actually quite fast compared to a lot of other jurisdictions. The cost, it depends on the stake or the complexity of your cases. You should really look into, find the counsel and really find out, hey, what could it cost you? The IP judges are getting more experience. In fact, compared to judges in other fields like criminal judges or commercial cases judges or civil case judges, Chinese IP judges are younger and probably more educated. This is really a general consensus. The IP judges probably the best quality body of the judges in China. The judges in China are more like specialized type of judges. Unlike the U.S., the one U.S. judge can deal with a wide spectrum of cases, criminal cases, commercial cases, the patent case, the trademark case. But in China, the court divided judges into different, we call tribunals. Okay, we have IP tribunal, criminal tribunal, civil tribunal. So it's relatively specialized. So we have found out, some Chinese judges are really, really smart. They can really dig into very complicated, technical and patent issues. And also Chinese court always actually updating the rules and regulations at a quite impressive pace. And they issue the judicial interpretation or advisory opinions, and the legislature are updating the patent law, the trademark law, copyright law. Right now, China is really amending its patent law, and China is amending the copyright law and the trademark law at the same time at this moment. So even though nobody expects this amendment will make everything perfect, but this kind of ongoing changes and the improvement or updates of the law offers the incremental or gradual changes, improvements. Just as some example, in the slide that showed a couple of examples here, the Streak is a UK company. They won the damages in the patent case. They got $1.4 million US. This is I'm not saying that in every case you can get this kind of the damages, but just one of the example that when things are really planned very well and they have solid case, the Chinese judges are willing to award a decent amount of damages. May not be the kind of damage you can get from U.S. court, but in the Chinese standard, the $1.4 million US is relatively substantial. Another example is the Neoplan. This is the German auto design company. They won a design patent case against 2 Chinese automakers. Automakers are considered very large Chinese companies. They got a lot of local government support. But in this case, the Beijing court did a very good job, I would say. They gave the $4 million to the German auto design companies for this big shuttle bus design, and that's a very impressive victory. So this is just a couple of examples that some positive outcome can be accomplished. The number 8 actions, the acting in groups. This is may not be something easy to be implemented. Okay, I say this is because based on what I know about U.S. and European companies, they tend to do things on their own. Here, I will actually offer sort of a little bit a different view. Okay, whenever possible, actually, we actually advise and recommend our clients. In dealing with the IP issues in China, it's quite important to get positive attention from the government at all levels, in China, the national and local levels. How can you get that? If you're a small one, right? And when you're not really big, when you're not doing that huge investment, probably the only way to do that is, actually probably 2 ways. One is that through diplomatic efforts, the U.S. Department of Commerce, USPTO, and the USTR, and the U.S. Embassy, they are very active. They are really willing to support the smaller companies. But the important thing is that, you need to find a way to group together. One of the natural ways to group the thing together is probably around the industry associations or business organizations. If you if you're active in some kind of industry associations already in the U.S., and some of your members run into the same kind of issues in China, instead of going one by one, okay, and it is probably a more productive approach. And by grouping together and using the industry associate's name and getting help from, through diplomatic channel, and using what we call the lobbying approach, not just policy. When people talk about lobbying, they're more thinking about, change the law, change the policy. It could be done that way, but in terms of action lobbying, it's if you are working, acting behind a very well organized professional organization or industry association, that might be really make it much easier to get some special attention from the government and to resolve your problems. So that's a very quick run through of what we call top 8 actions in the China IP world, and that's the end of my presentation. I will probably leave the time now for some of the questions.
Thank you, Lawyer He. Don't be shy. Lawyer He has lots of experience in advising companies, and he's happy to take questions over the phone today. You can also email him at his email address at zypartners.com. Operator, can you tell people how they can call in?
Thank you. At this time, if you would like to ask a question over the audio, please press star 1 on your touch-tone telephone. You will be prompted to record your name in order to be introduced. Once again, please press star and 1 on your touch-tone telephone. Please stand by for any questions. One moment. We have a question from Kathy Fike. Your line is open.
Hi. I have a lot of clients that have concerns about whether they're filing for a patent or a CE mark or something in China. They're worried about when they have to give the details of their product, the plans and stuff. They're worried about that's going to get to their competitors in China. How valid is that concern, and how do you respond to that?
The CE mark, right? This is more about the certification.
I've had it for both, actually. I've had it for registering a patent there as well.
Well, for registration patents, that's more about what we said regarding the clarity of the specification, the insufficient disclosure, and that's not probably more. It's probably less about the trade secrets. Okay, it's more about whether we really disclose enough information to support the claimed invention. All right, and we have not seen the Chinese patent office. Well, this might depend on the different technology sectors. It might happen more on the bio industry, as I can imagine. But generally speaking, the disclosure in the patents more become an issue for the invalidity cases, okay? It's not happening very often that the patent office will directly asking the patent applicants for more disclosure or information at the time of the patent filing or during the patent examination, all right? But this may not be the same for the bio patents. Okay, I'm not really. I'm more on the electrical or mechanical type of patents. I'm not my background is not really about the chemistry or the biology. So that's the part about the patents. The simple message for patent is that, hey, normally whatever you use for filing in the U.S. or Europe should be sufficient for filing in China.
Okay, good to know.
We're not really asking you something more. For the certification thing, that's much trickier, all right? From what we have heard, that it is quite a controversial area. In China, this is what we more refer to as a market access problem. Okay, if you're talking to the European delegation here, maybe it's U.S. embassy as well, the companies are really not so satisfied with the certification procedure. For lots of products, especially for technology products, getting to China, they have to go through certain certification, and then the certification center will, asking all kinds of questions, asking more details, or the procedure getting very long, or sometimes getting very expensive. There are really no perfect solution at this moment. Okay, I don't know what to offer to your clients. Probably the best way to say is it is a risk. Okay, it is a risk. But if the client really want to get into China market, probably the most reliable way is that to find a very good local, maybe consulting firm and agents that have a relatively reliable relationship with the certification center in the relevant sectors and have the job done. It's really, most of the time, it's really the communication job. If the smaller companies have no presence in China, it is not easy to communicate with the Chinese, the technicians, the officials in the certification center. It's not hard to imagine. There will be lots of problems come up. Even if we're not talking about those leak of the trade secret issues.
Okay, very helpful. Thanks.
Once again, if you would like to ask a question, please press star and 1 on your touch-tone telephone. Once again, that's star and 1. Please stand by for any further questions. We have a question from Cora Knutson. Your line is open.
Thank you. You had mentioned a couple of Internet sites. We're familiar with Taobao, but I didn't catch the name of the other one. Would you be so kind as to spell that for me?
Dangdao, D-O-N-G-D-O.
I said Dangdang is another one. And also 360buy.com is another very popular one. They're probably getting better. I think they're putting a lot more business to themselves. Some of them building themselves as a D2C site. That's a little bit better. The C2C sites are the most problematic site.
Thank you.
Cora?
Yes.
I just wanted to let you know that we actually did a webinar with a lawyer from Taobao and a lawyer from its sister company, Alibaba.com, and they explain in step-by-step how you can file a complaint if there was an unauthorized posting to those websites. And you can find that on the stopfakes.gov webpage, or just shoot me an email, janice.wingo@trade.gov.
Wonderful. Thank you so much.
Yeah, for those Taobao procedures, I think still the thing that people are not satisfied is that the Taobao still following those take-down notice type of approach. Okay, you have to send the report to them. They actually, from what I heard, they act quite fast, and they can take those down. But the problem is that the online vendors will repost or find another way to post the same kind of thing, the listings again, okay, without paying anything, and that's become like a tricky game now. Taobao is not willing to, proactively filter them out or get rid of the other, the same kind of counterfeit listing. And they have appointed 2 outside service providers, which we think they have some equity interest in that as well. They say, hey, if you go through that 2 investigation surveillance companies, actually one of them have a strong, the government support. If you use them, they can do automated monitoring. They can send us the listing on weekly basis. Then we can automatically take them away. All right. One of my clients is doing that, and apparently the report is not bad actually, the result, but it just does not resolve the problems. Okay, things are still keep coming up, and some big brands are not comfortable to work with those 2 companies, and so they still want the Taobao to come up more systematic approach. But so far, this is still being, it's really not resolved. The Chinese central government, the latest the news is that they want to use this blacklist approach to deal with some online vendors. Basically, the idea is, hey, if we receive a lot of complaints about this vendor, then the online trading platform should completely ban the entry of that online vendor. Or if the online trading platform always has a problem, they could impose some serious punishment against the trading platform.
Wonderful. Thank you.
And at this time, I am showing no further questions. Once again, if you would like to ask a question, please press star 1 on your touch-tone telephone. That's star 1. Please stand by. For Knudsen, your line is open.
Hi, my name is John Zane. I'm listening to this webinar. It's very useful. My question is, we are fairly new to the Chinese market. While we're talking with our prospects, we don't have any relationships with them yet. Some of them, they went ahead and create their own names for our brand. And it's quite annoying. Shall we go after them or shall we ignore them? What we need to do?
That's exactly the problem. We talk about the early registration of your trademark, right? The Chinese people, the counterpart, the prospects, they're very smart. They can smell whether your brand's going to be popular here or not, and they will probably keep thinking about, maybe actually your mark, your brand already had a counterpart Chinese name, maybe in Taiwan or Hong Kong, right? The Chinese Greater China market. People will do the search. If the mark is not really introduced in China, hey, those prospects are probably more than happy to register that mark first. Okay, without your knowledge. What you need to do, okay, this is actually it's quite a risky situation now for you. If you have some genuine interest in China market, then ideally you should get some advisors, give some advice about your potential China mark, and you register that yourself first. Okay, that's the first thing. The second thing is for those prospect, well, if they're individuals, tough, but if they're companies, you should hire maybe a trademark agent and a law firm to monitor the publication of a Chinese trademark office. Okay, if someone trying to register your mark or the Chinese counterpart, Chinese the law allows a 3-month window time for you to oppose it. Once you oppose it, that mark will sit there for quite a long time. Okay, so you need to have some monitoring system. But first of all, you need to register at least your English mark, your as soon as you can. If you have not done that, you should do that immediately, and have a good coverage, and start to think about maybe at least a transliteration of your English mark, and register that in as a Chinese name. That's one of the things you need to look at. But you cannot sue those people directly right now. Okay, if they say, hey, I want to register your mark, even if they register your mark, you cannot sue them, or just so you know. Okay, but you can oppose their trademark filing. But that requires some monitoring activities.
Thank you.
Does that help, John?
Yes, it's helpful. Thank you.
This is Janice. Can I just make a plug here? We also have a webinar on trademark fundamentals, and if you shoot me an email, I can send you the link to it. It's usually posted at the stopfakes.gov website, but I can send you a link because we're revamping the website right now.
Once again, if you would like to ask a question, please press star one. One moment. Kathy Feig, your line is open.
Hi, it's Kathy Feig again with Department of Commerce. If I have a client company who registered their patent in the U.S. 10 years ago, is it too late for them to register their patent in China?
Correct. That's too late. That's too late.
So what other options, how would you, if you were that company, is there any other route you could go to protect your product in China?
Normally, this is what I would do. The company would have probably make some effort. Okay, have the engineer sit down again. Ideally, work with someone who knows China market and think, hey, this is the patent. Whether this product could be improved a little bit in adaptation to the China market. And actually, in China, just so you know, we did not touch about this, right? Just so you know, China has 3 types of patents. Invention patents, that's equivalent to the U.S. utility patents, right? In China, it's regarded as sort of more sophisticated technologies and methodologies, okay, that covers formulas, components, everything. But there's another type of patent we call the utility model patents, okay? This is a type of patents that are registered without examination, okay? And it just is intended to cover those sort of simple improvement or minor improvements, especially for mechanical parts or less complicated electronics type of patents. Many Chinese companies using that. Okay, the cases where Schneider lost for $40 million US is because of that type of patent. So it's not that hard, I think, for a U.S. company to change something and then make it arguably some new advantages or more utilities, more use, some more efficient or whatever, and then file that with something new in China at least as a utility model patents. It's not expensive, and that will give them a coverage.
A brilliant idea. Thank you.
Once again, if you would like to ask a question, please press star one on your touch-tone telephone. Once again, that's star and one.
Anyone who's listening to the audio recording, Lawyer He said he'd be willing to take questions, so just because you can't ask him live, he's still happy to answer your questions, and you can reach him at jing.he@zypartners.com. You can also call the China desk at the Department of Commerce, and the number is 202-482-2590.
And by the way, our firm also has a very good weekly IP blog that will provide you some very fresh information about what's going in China. We're also quite generous in terms of offering comments, recommendations to dealing with some IP issues in China. So you're welcome to check our website and sign up our newsletters.
And at this time, I am showing no further questions.
Okay, well, Lawyer He, we'd like to thank you for your time. I know it's quite late, and you're not even at home. You're in Singapore, so you're doing this on the road. We appreciate your time. I just wanted to remind the listeners that we have a presentation on April 2nd from an officer at U.S. Customs and Border Protection, and she's going to explain how you can record your U.S. trademarks with CPB here to keep unauthorized goods from entering the country. That's on April 2nd. I'll be sending an announcement around. Thank you again, Lawyer He.
Thank you, Janice. Thank you, everyone, for taking the time to be in the webinar.
Thank you. That does conclude today's conference call. Thank you for participating, and you may disconnect at this time.